May I move that we recognize the next interpellator, the gentleman from Pampanga, Senator Kiko Pangilinan.
Yes,
So
Mr.
moved, Mr. President.
Senator Pangilinan is recognized and may proceed. Should the gentleman, sorry, sir.
Yes, Mr. President.
Yes, Mr. President, this is not an interpellation, but with the permission of the gentleman from Tarlac, we will just make a manifestation.
The gentleman may proceed.
Thank you, Mr. President. Mr. President, marahil marami ang nagtataka o nagtatanong ano nga ba ang pinakapunot dulo o debate na pinag-uusapan dito sa Senado. Tatlong sa probisyon ng saligang batas. Tatlong kapangyarihan ng tatlong sangay o tatlong governmental entities. Yung kapangyarihan ng judicial review ng Korte Suprema, yung sole power ng House of Representatives to initiate impeachment proceedings, at yung sole power ng Senate bilang impeachment court para litisin at pagpasyahan ang isang impeachment case. Narito tayo ngayon, nagdedebate dahil yung judicial review power ng Supreme Court ay pinawalang bisa ang sole power ng House of Representatives para ito ay mag-initiate ng impeachment proceeding, at pinawalang bisa rin ang kapangyarihan ng Senado bilang sole having the sole power to try and decide impeachment cases. Dahil dito, saan tayo tutuloy? Merong na ring mga ruling ang Korte Suprema kung paano natin iha-harmonize o ihahambing ang mga nagtatalong probisyon ng saligang batas. Sinabi ng Korte Suprema sa kaso ng Civil Liberties Union versus the Executive Secretary, pati na rin sa Francisco case versus HOR, the Constitution is to be interpreted as a whole, and one section is not to be allowed to defeat another. In this case, the judicial review should not be defeated. The sole power of the House to initiate should not be defeated. And the sole power of the Senate to try and decide cases. All mandates, all duties, all constitutional powers that do not belong to us, that was given to us, not by any whim, but by the Constitution, all of whom here sworn to uphold and defend. Kaya, ano ang way forward? Sabi nga, may mga minungkahi, si Justice Ascuna, hayaan sa MR, payagan sa motion for reconsideration, payagan na magkaroon ng operative facts doctrine para yung anuman ang pinagpasya ng Korte Suprema sa kasong ito should apply prospectively, number one. Pangalawa, ay sa pamamagitan ng MR pa rin ay mabigyan ang House of Representatives na maituloy ang kanyang kapangyarihan to initiate, and at the same time, mabigyan ang kapangyarihan ng Senado to try and decide the case. Kaya habang naririyan ang MR, baka sakali, at nangyari na nga, na the Supreme Court has reversed itself, even in a unanimous decision. But even assuming it does not reverse itself in this case, the Supreme Court may modify its ruling. And therefore, if it modifies the ruling, assuming that it modifies but does not reverse itself, should we not await the resolution of the motion for reconsideration before we vote? Today, we hold it in abeyance or we table it. Mr. President, if I may add, the SC, the Supreme Court, hindi niya binanggit binanggit niya, nawalan ng jurisdiction ang Senate Impeachment Court. Pero ang ibig sabihin nun ay pinawalang bisa, ginawang void ab initio ang mga kilos at pasya ng Impeachment Court. The convening of the Impeachment Court was voided. The majority decision to remand the complaint to the HOR was voided. The summons by the Impeachment Court were all voided. Which brings us to the question, who now is deciding the impeachment case? Now that all the decisions of the Impeachment Court have been voided. It's a tricky question, Mr. President. But if I were to be an impeachment court judge, I would argue that we have to, in the MR, in the motion for reconsideration, intervene and uphold the impeachment court's exclusive power to try and decide the case. Why? Because it is the constitutional duty to do so. It is the order of the Constitution. We are not defying the judicial review powers. We are upholding the sole power of the Senate to try and decide impeachment cases. But, having said that, sabi nga, it is our view, and this is shared precisely by former Supreme Court Chief Justice Pangilinan, former Chief Justice Puno, former Constitutional Commissioner and Justice Ascuna. They have seen, or they have read their decision, and they too have said that the Supreme Court erred on a matter of facts. And if the Supreme Court erred on a matter of facts, how can you be right with the law if you are wrong with the facts? And if you are not right with the law, why will the impeachment court and the Senate, for that matter, decide on the matter today? Why not wait for the motion for reconsideration? Siguro naman, hindi natin binabangga ang Supreme Court, hindi natin binabangga rin ang House of Representatives dahil meron ding prinsipyo ng parliamentary courtesy, meron ding prinsipyo na kinakailangan natin bigyan ng respeto ang co-equal. We are a co-equal to the House of Representatives. Ano na lang ang magiging repercussion na ito ang House of Representatives nag-file ng motion for reconsideration, hinihiling nila sa Supreme Court na baguhin ang ilang mga findings of facts, baguhin ang kanilang naging desisyon, habang pinangunahan ng Senado ang House of Representatives at sinabi, wala kaming pakialam sa inyong motion for reconsideration, i-dismiss namin ang kasong ito. I think, out of courtesy for a co-equal, we should respect the House of Representatives. In the same way, if the Senate would, at a future time, file a case before the Supreme Court and seeks a motion for reconsideration in a matter that involves the House, we would like to think that the House will not act to have the case dismissed pending the MR out of respect for a co-equal. Sana, pag-aralan natin ng husto ang pagpasya ngayong hapon. Sabi ko nga, the findings of grave abuse by the Supreme Court, thereby removing or taking away from us the jurisdiction, na wala tayong jurisdiction, that jurisdiction was not acquired on the basis of facts that are flawed, where then is the grave abuse? I don't know what the ruling will be. Perhaps they will say, yes, there was no grave abuse of discretion on the part of the House because of the 1-year bar, which was not actually, the fourth complaint was not bar. I don't know. But whatever it is, hintayin na lang naman sana natin. Respetuhin naman natin ang ating co-equal. Why the convening of the impeachment court is the way to go? Dahil pag tayo ay bumoto ngayong hapon o ngayong gabi na i-dismiss ito, aksyonan ang impeachment complaint, we will be acting beyond, without legal authority dahil wala naman sa atin yung impeachment complaint. Wala namang kapangyarihan ang Senado in plenary, ultra vires, without legal authority, ang magiging desisyon natin. One final point. In the Corona impeachment trial, nang himasok, nag-TRO ang Supreme Court para sa mga bank accounts. Ano ang ginawa ng Senate Impeachment Court? Bumoto 13-10 para respetuhin ang Korte Suprema. I did not vote in favor of the TRO or respecting the TRO. But the Senate, as an impeachment court, voted and we respected it. Because it was the Senate Impeachment Court that decided. It was not the Senate. It was the Senate Impeachment Court that, seeing perhaps that we needed to harmonize the power of judicial review, the power of the Senate as an impeachment court, to have the sole power rather to try and decide cases, seeing that the Senate impeachment court decided to harmonize the conflicting provisions of the Constitution. I think we should, as a Senate impeachment court, do the same. Kung ipagbobotohan na respetuhin ng Korte Suprema para walang constitutional crisis, so be it. But it ought to be the Senate Impeachment Court that asserts its sole power to try and decide impeachment cases. Yun na lamang po, and I associate myself with the motion of the minority leader that we lay on the table the matter of the impeachment case and action.
Just a point of information, for the record and for the information of the body. Chair confirms the manifestation earlier of Senator Cayetano with respect to Section 4, Rule 39 of the Rules of Court that says that decisions of the court are not immediately executory unless the decision says so. In this case, the decision specifically stated that it is immediately executory. Number two, again, just for the record,